from the College by the Lake, Coeur d'Alene, Idaho. Local, regional, national, and international guests discussing the issues and topics affecting the way you live are on Forum, the North Idaho College Public Forum, with your host and moderator, political scientist Tony Stewart.
Our topic for today's program is the practice of law and professional ethical guidelines or ethical codes on which that those who practice law follow. I'm so pleased to welcome back to our program a guest last week who dealt with a different subject. We talked about the radical right and the Constitution, but our guest is Jim Vacher. Our guest holds a BA degree from Washington State University, received in 1969, and his Doctor of Jurisprudence is from the University of Washington that he received in 1972. Since 1975, he's been a member of the faculty of the law school at Gonzaga University, where he teaches criminal law, professional ethics, civil rights, and jurisprudence. Our guest is also the former dean of the law school. Jim Vacher has been a friend a long time, and Jim, you are very kind to come and spend these 2 weeks with us and share this really important information with our viewers, and we thank you very much.
Thank you. I'm glad to be back. I'm looking forward to being interrogated.
And I'm so pleased to have our regular panelists. First of all is Janelle Burke, who's an attorney in the state of Idaho. And next to her is Steve Schenck, who's the Dean of College Relations and Development at North Idaho College. And we shall ask Janelle, who's a former student of our guest, to start the questioning today.
Well, I was just going to mention that indeed I was a former student of Professor Vacher, and it's a pleasure to have him here on the show, so I get to ask him questions instead of the opposite way around. I do know that, and we'll share with our viewers, that in your classes there were always ethical considerations that in any subject that you were teaching, you were concerned about the ethics of the situation. Today, as we begin the program, I would like to talk something about the codes of ethics that have been developed. Almost every bar association has codes of ethics that they've adopted that lawyers adhere to. Can you explain how those codes of ethics are adopted and also what they are?
Sure, and I'm glad to be able to answer your questions. I'm sure I owe you more than a couple answers after all these years. It's good to be here to talk with you. It is universally the case that lawyers are regulated by codes of conduct that have been adopted by either the organization to which they belong, the Bar Association, which in most states is a mandated organization for lawyers to belong to, and either those organizations or the courts of every state and the federal courts for federal practice impose very considerable legal controls as well as ethical standards on lawyers through various kinds of codes. And they are fairly consistent about the country, but there are differences from state to state as well.
Can you give us an idea of what kinds of subjects are included within the codes?
Sure. There is, for a very large majority of the states, somewhere in the neighborhood of 40 of the states have adopted one form or another of a model code that the American Bar Association promulgated in the early 1980s. It regulates client-lawyer relationships, conflicts of interest, duties to the adversary system, to judges and the justice system, and to other participants in it. It regulates and encourages certain kinds of norms of behavior about pro bono work, and it establishes the rules about when you will be disciplined and when you will not be disciplined for your behavior.
Now, in addition to what we might consider somewhat the standards that have been promulgated, there are also in most attorneys' minds some kind of moral standards by which they are governed as well. Wouldn't you agree?
Oh, absolutely so, on more than one ground. First, the rules that I'm talking about are themselves grounded very often in fairly clear moral principles, but in addition to that, at least the way that I teach and the vast majority of lawyers that I know who practice law consider themselves to be morally bound to certain kinds of behavior. It may seem far-fetched for lay people to consider it virtuous behavior, but in fact, in many circumstances it is. It may not look like it from an outsider's perspective, but that's because lawyers sometimes have to engage in practices that the ordinary citizen doesn't understand, doesn't appreciate, but is required to do because of the nature of the representation.
And what kinds of things would be included within those moral standards, would you say?
Well, I can give you a couple of examples. One is that one of the centers of a lawyer's obligation is to maintain the confidences and secrets of clients. When a client speaks to a lawyer about past events in part of the representation, then the lawyer, absent some very special circumstances, must keep that quiet, must keep it secret, even in the presence of pretty legitimate claims that it ought to be disclosed. Let me give you the simple example, and I'll give you another example of an ethical dimension of practice. Suppose that a client comes to a lawyer and says, "It is indeed the case that I committed the crime." Let us say it's murder. The lawyer is then holding awful knowledge about an event that took place. But she is required to keep that sacrosanct and secret, much as a priest or a minister in the confessional must keep that kind of secret. So that's one example. Another example of moral an ethical dimension to practice that's not often thought about, and that's the issue of conflict of interest. You can't represent both the sides on a lawsuit, that is, the opposing sides on a lawsuit, because you would then be conflicted. You would have loyalties in both directions. And that's a very simple principle. We can think of it back to our Sunday school days. You can only serve one master, you might remember. That's a moral principle that's incorporated in some fairly technical rules.
And also the question of honesty to the court.
Absolutely. That's very good, and Janelle remembers well the lawyer's obligations, and I'm glad that she does. If a client tells you that he or she is going to lie to a court, you have an obligation to prevent that from happening. Excuse me. You have to be truthful in factual presentations to courts. You can't lie about the state of the law, and you can't let clients lie either.
I want to approach this whole question from more of a layperson's point of view.
Sure.
I'm not an attorney like Janelle, and I suspect most of our audience are not attorneys either. Can we talk a little bit about the whole concept of self-policing associations, which are, I guess, what bar associations are? If a lawyer commits a criminal act, then he or she is held accountable by the same standards any of the others of us are. But for an ethical transgression, it's the bar association that steps in. Does it work?
It works, and I want to clarify a little bit. Typically, it's not just the bar association. It's the bar association acting on behalf of the court, which is a government entity, just like the legislature, except that we are responsive to the court. And the reasons for that are tangled, but they have to do with separation of powers and a fear that the legislature would gain too much control over the process of lawyering and law development by the courts. Does it work in the sense of, are most lawyers ethical? I think the answer to that is probably yes. Does it work in the sense of, are we pretty certain that miscreants are caught and punished for their transgressions? I have to be honest with you and say sometimes yes, sometimes no. Some states yes, some no. I think in the last 15 years there has been increased attention paid to the problems of enforcement of the rules, and I think it's improved dramatically. One of the interesting things that has happened when you talk about self-regulation is that in the last few years, most states have gone to a method of disciplining lawyers in which laypersons are parts of the panels that make decisions about discipline.
Very interesting. If I can follow up with another question. Like you, I think most lawyers, as most people are basically honest and try to do the right thing. When people stumble, therefore, I'm going to assume that they did it inadvertently. Is there an area that you see where lawyers sometimes make mistakes more frequently than others, an area of ethical conduct that they inadvertently run afoul of?
Let me give a brief thought to that. Probably the one where we're most likely to run into difficulties like that are in the area of competence and communication with clients. competence requires lawyers to be as good as the next lawyer, and that's not always possible. Let's admit it. Time sometimes imposes constraints. The busyness and the business of practice also very often leads lawyers to be very, very busy, and they sometimes forget their central focus is on their client, and so don't communicate as well as they might with them. I think that's probably an area where there's most inadvertent mistakes made.
Thank you.
We hear a lot of discussion by laypersons about law because a lot of people have been affected somehow, either in civil law or criminal law, and you often hear comments by laypersons about the aggressiveness of attorneys. And certainly we've had some famous cases recently in our country in which attorneys on both sides were very gifted and were very aggressive. The O.J. Simpson case to point. What would you say to our audience, as you would to a class, of how far should an attorney go? Of course, you've explained really clearly some of the ethics and responsibilities they have to their client, and also what they cannot do before the court. But there is some leeway about the aggression and what you can say to try to influence the jury, and what kinds of guidelines does one find in professional ethics in various states to deal with that issue?
Well, I can assure you that the question that you're asking is one not only that the lay people and public ask, but it's one that lawyers debate endlessly amongst themselves. It's sometimes referred to as hardball litigation or sleazy tactics. There isn't any question that there's a considerable amount of that. How much is really hard to say, but there's enough that it's measurable and it's a concern. And I will say that there is considerable amount of discretion in a lawyer. And if you think about it for very long, you will realize that that in part has to be there, because lawyers represent clients, and clients are in control of the direction that litigation takes. If a lawyer is responsive to the client and the client demands an aggressive attitude, then with some restraints, which I'll mention, that's the lawyer's responsibility. It's a lawyer's responsibility to educate the client of the risks and dangers of too aggressive behavior. It's a lawyer's responsibility to respect the bounds of advocacy, which are present. Janelle mentioned those a little bit. We can mention them again. You can't lie to courts. You can't abuse people. You can't engage in tactics that are merely designed to embarrass and delay. And there is those kinds of restraints on lawyers' behavior. It doesn't restrain the worst of behavior sometimes, but what we've seen is more and more the courts are becoming more aggressive in disciplining and restricting the behavior of lawyers in these tactical environments. For example, the Washington State Supreme Court on several occasions recently has imposed very significant monetary sanctions for lawyers who cross the lines of decency. But I think it's important to keep in mind that aggressiveness goes hand in hand with an adversary system. The issue is, where should we draw lines? I should also note that many bar associations and many lawyers personally have begun to accept a sense about being a lawyer that includes more attentiveness to kindness, in a sense, to avoidance of hardball tactics. That's a growing movement within the bar.
Let me take this one step further.
Sure.
We also, in these famous cases, see judges with very different styles.
Mm-hmm.
And some judges use a style. Of course, they're attorneys, too, and they certainly are in charge in the courtroom to make sure there is a fair hearing by both parties. But some judges use a style in which they, even though it's a major case, things are very efficient and they move along and it happens in a certain amount of time. Other judges, it's a very prolonged process. In fact, some judges have even been have been charged with the idea that they might lose partial control in the courtroom with attorneys if they do certain things. That's a kind of involved question, but what, under this whole professional approach, are there certain guidelines that judges try to follow, or is there any changes because of some celebrated cases in recent years?
An excellent question and perfectly related, and as it happens, I have recently been teaching this very topic to my class in this subject, and I think we probably need not mention the names of particular cases to get the idea. I will point out to you that I, as a lawyer and a member of the bar, have restraints on me that the ordinary citizen doesn't have in criticizing judges, and there's a special rule that deals with that. That's not what you ask. The answer is that judges, just like lawyers, are subject to very significant control of their behavior by codes of judicial conduct, is what it's typically called. And in those, many of the same kinds of rules, translated slightly, transformed because it's judging, not lawyer practices, are imposed on lawyers. For example, there is an ethical rule, an ethical principle, and a black letter rule that says judges should be efficient and get their cases decided in a timely manner. Judges should not engage in discriminatory treatment. Judges should not be dilatory. So there are very similar rules that apply to judges. And in many jurisdictions, although it's a controversial problem about how to discipline judges, there has been pretty strong movement recently to make sure that judges live up to that set of expectations too.
Thank you. Janelle Berg.
My next question will have to do with attorney's fees. There are certain limitations for attorney's fees, or at least considerations that attorneys should have in dealing with their clients with regard to fees. I hope you will deal with 3 areas, one having to do with how to set attorney's fees, or what a client can expect, and how to relate to their attorney about those fees. The second one having to do with fees that are pro bono type fees, situations in which there might be pro bono type fees. And then the third one having to do with lawyers that sometimes might misuse their fees, that's abuse of fees in their trust funds and so forth.
I see. I'm
And
a
you
good
can
student. I
address
took
those
notes.
at
So
any-
I noticed you were taking
three-part
notes
question.
while the attorney was speaking.
On the question of fee setting, now ordinarily one might think that the marketplace ought to control how much people charge for their services. In fact, that is not true with lawyers. Lawyers are bound by their ethical codes to charge what can be referred to as a reasonable fee. And that's not a meaningless term. There are, in most codes that I'm familiar with, have what are called lodestar factors. There are 8 factors that you take into account in establishing your fee. And if you don't take those into account and charge an excessive fee, you can both be sued by the client, and there are a fairly large number of complaints, and they're handled in Washington at least by an administrative process. And excessive fees in many jurisdictions not only violate lawyer codes subjecting a person to discipline, but violate consumer protection laws subjecting them to claims under consumer protection. So the fee question and reasonableness of fees, even though there are some obvious examples from time to time of excessive fees, are clearly regulated. You didn't ask about contingent fees, but I'll mention as well that the contingent fee is also fairly restricted in its use, and there have to be reasonable limitations on the collection of contingent fees. That is, recovering your fee based on the amount that you recover for the client. There are pretty significant restrictions on that. One of the things I talk to my students about all the time is that being a lawyer is a profession, but it's also a business. And when you run a business, you have to generate enough income to pay the bills and make a living, and so that's where fees come in. But we are controlled in the amount of fees that we charge. The issue of pro bono, and I'm glad you brought that up. Lawyers generally feel a personal obligation, almost all of them, many of them at least, and the bar associations that regulate their conduct encourage, direct, and sometimes require them to donate their services to the poor. That's what pro bono work is. That's not getting any fee, it's getting no fee and only perhaps expenses to represent persons who can't afford a lawyer. Lawyers have historically taken on that obligation and continue to do so. There's great unmet need for poor people's legal services in most communities, and lawyers are trying to step in and fill that gap with the defunding or reductions in funding to government legal services. So pro bono work is an important part of what most lawyers do. And the last question you asked had to do with fee abuse and the possibility of misusing trust funds.
Yes.
For those, we should make clear, and this gets somewhat technical, but generally when a lawyer receives funds from a client, the lawyer must segregate those into very special protected accounts and keep very close track and not commingle funds or use them without the client's permission. If a lawyer transgresses that rule, usually it's fairly easily discovered at some point. When it is among the most severe violations of trust that a lawyer can engage in, and regularly and routinely lawyers are disbarred for that behavior when it occurs. Disbarment referring to being taking away your license to practice. Not only that, but in Washington and many other states, and I'm sorry to say I can't be sure about Idaho, lawyers are subjected to random audits, that an auditor can visit regularly without warning to check on the status of those books. So it's an area where unfortunately tragedies have ensued, but it's also one where disciplinary authorities are very firm in denying that lawyers have any discretion in handling client trust funds.
When there are
Excuse me.
questions about fees or questions about something that has to do with the fee structure or the handling of money, do you encourage clients to contact their lawyers and free communication between the lawyer and the client with regard to that issue?
Absolutely. Just as with any other merchant or any other provider of services, it's important to get very clear communication with the lawyer. It should be noted that the rules almost always in all jurisdictions say that it's the lawyer's duty to communicate clearly with the client and on a regular basis. And the failure to do that, as I mentioned earlier, is a great flaw and one that can be corrected by the client being clear and asking the lawyer for information and understanding. If there is a fee dispute, there are lots of possibilities. Quite commonly, the bar associations of each state have a mechanism for fee dispute arbitration.
Steve Sheen.
You mentioned in response to one of Janelle's recent questions that the abuse of a trust fund is one transgression that could result in first-time disbarment for an attorney.
Mm-hmm.
Are there others, or would most require multiple offenses before disbarment, which is the ultimate step to be taken?
That's a deceptively simple question. I'll try and give a straight, clear answer to it. Probably those kinds of transgressions are going to be clearly result in disbarment, and next in line would be abuse of clients in one fashion or another. If we have the unfortunate and tragic incident where you engage in some kind of abuse of a client, physical or otherwise, sexual abuse, that kind of behavior also leads to very drastic sanctions. Many other kinds of behavior probably don't by themselves. The one that is interesting possibility is if you are not engaged in a client abuse, but if a lawyer, heaven forbid, were to commit a serious crime that didn't necessarily have anything to do with the law or being a lawyer, very often that leads to temporary suspension and in the long run disbarment. But I think the trust fund is the big problem, abuse of clients.
Well, that prompts another quick question, and that would be, is disbarment a permanent sanction?
Yes, but just like anything else in our country, permanent doesn't mean forever necessarily. Lawyers have the right, or at least the ability, to petition for reinstatement after a certain amount of time. And it does happen from time to time. Upon a showing of very complete rehabilitation, the lawyers are allowed not to practice law again, but the opportunity to take the bar exam to see if they're fit to practice law again.
I see. If I could be allowed one final question. You're not just a lawyer, but you're an educator and a former law school dean. In your view, are law schools spending enough time in this area? Do they teach enough ethics as part of the curriculum?
Well, of course, I think that half the curriculum ought to be ethics. Most law schools, since the Watergate affair, which generated most of the response on this, devote 2 or 3 credits to a specific course, but also, as in our law school and many others, we have made a commitment to inject or engage in a pervasive ethical analysis in all courses. Could they do more? Certainly. One of the hardest questions is, can you teach people to be virtuous? So I'm on the side of Socrates on that point, and I believe that you can. Lots of people disagree with that, so there's some debate about it. But in terms of making sure that students understand their basic ethical requirements and the rules, I think the law schools generally do a pretty good job.
Can I sneak in one last final row?
Sure.
Do lawyers, some professions require continuing education to retain a professional license. Do lawyers have to go through that?
Most states do. Idaho does.
Yes, and it also has an ethical requirement as well
Right.
in your continuing education.
Washington has, you have to gain a certain number of credits per year, And in the recent past, have adopted a rule specifically that you have to have at least, I believe it's 5 hours a year of refreshment on professional ethics. In fact, I'm glad to be here today. The rest of the month I'm going to be teaching continuing legal education classes.
Well, I know our viewers appreciate the fact that you've informed them on so many things that will be helpful, and I'm sure there'll be some people in the field of law who've watched the program. Something else that we hear, again, if I can go back to the laypersons, and there'll be a terrible crime take place, and there appears to be an awful lot of evidence against the arrested party, but yet there's not been a trial. And you hear from time to time some criticism of an attorney defending that client of this very heinous crime. Would you speak to that issue and what the Constitution has to say about the right to counsel?
Absolutely. I think it's one of the hardest questions that you have to deal with as a lawyer, and our students struggle with this when I present it. How can you defend an obviously guilty party? Okay, that's the question that gets, and it takes various forms. The simple and short answer is that the issue when we get into the court of law is not purely factual guilt or innocence, is can the state prove the case beyond a reasonable doubt? We want to ensure dignity and autonomy to all persons presumed to be innocent. The lawyer's job is to make sure that when the state tries to try someone for a crime, that it proves its case. There's room there then, and a difference between factual guilt or innocence and legal conclusions about that, and that's where the lawyer operates. And the lawyer serves an important function, in my judgment, to preserve the autonomy and the dignity and the privacy of each individual. And we know there are occasions in which there are miscarriages of justice and supposedly guilty people are not. That's not the only reason lawyers do it, but it's an important one.
Also, the courts, like everything else, that we're human and we're not perfect and there can be mistakes, but sometimes we, I think, expect the court to function without any error at all.
That's right, and it is a human institution. Lawyers make mistakes, judges make mistakes, prosecutors, police officers.
On that note, I have to bring the permanent conclusion on behalf of our panel and our staff. It's gone so fast, but we thank you so much. Jim Vacher from the Law School at Gonzaga University, you've been very informative.
Thank you.
Ladies and gentlemen, I hope you'll be with us again next week at this same time when we will move to yet another, what we believe to be an important issue, and I hope you'll be with us that time. Until then, please have a good week. I am Tony Stewart.
The North Idaho College Public Forum was videotaped live from the studios of Instructional Technology on the campus of North Idaho College for viewing at this more appropriate time. We invite you to join us again next week for another all-new edition of the North Idaho College Public Forum on this public television station.